Good afternoon. I think everyone's come back in. Good afternoon. I'm Lauri Cleary, and this is Jace Tilley. We are going to talk about trade secrets and confidential information. The slide that you're looking at, the title of our presentation, As Advertised, is a bit overbroad. We're not going to be talking to you about every way you can protect every one of your business interests. We'd be here for weeks, months, years, so we're not going to do that. We are going to talk about sensitive information, whether you call it a trade secret like the formula for Coca-Cola, or less closely guarded proprietary or confidential information. And I want you to think about it kind of intuitively, because the cases are all over the place. They are very fact specific, but we're going to give you a lot of the guidelines and the things to think about, as opposed to going through a whole lot of different fact-specific case situations. It'll be hopefully more useful to you. So has anyone ever asked you, can you keep a secret? Yeah, sure. Everyone gets asked that. Let's think about it and let's break it down a little bit. So first, is the information really a secret? And second, what are you being asked to do to keep it a secret? Is it going to be difficult or easy to maintain that as secret? So think about that as we go through this. If a colleague comes to you and says, can you keep a secret? And then tells you that Jane and Joe in accounting are having a torrid affair, you may say, that's no secret. Everyone knows that. Jane and Joe have not made any attempt. They haven't been on the kiss cam at the Coldplay concert, but they've been very public about the way they feel about each other. So that means basically they've made no efforts to keep it a secret at all. And that's the kind of thing we're going to be talking about, efforts to keep something secret. Why? Because it's important, and it's important that it maintain its secrecy and its confidentiality. So the key questions in this area of the law are no different from the Coldplay example. They focus on whether the information is really secret or confidential, and whether the information has been the subject of efforts to keep it that way, even if those efforts fail. So we can switch slides. I'm going to ask Jace to do this. Okay. You have so many buttons up here. I don't want to press the wrong one and have the whole presentation go fluey. Okay, so our goal today is going to be to try and achieve three objectives. The first one is to understand basically what a trade secret is, as opposed to just other confidential information and information you may want to protect. A trade secret is entitled to special protection, and there are statutes to do that. Many of you probably know this already, so if it's too simple, sorry about that, but we've got a variety of levels of sophistication in our audience. We will also want you to understand what you can or must, in some cases, do to protect the information. And we want you to understand what we can do if your information gets out or is misappropriated. So the legal protections in this area come from a few sources. First, there's the common law, what we call the common law cases about these issues. Employees during their employment have a common law duty of loyalty to their employer. And that means that they have to keep confidential information that they know to be confidential, keep it confidential, maintain its secrecy, if it would hurt the employer for someone to have that disclosed to them. In very general terms, anything that would harm the employer's business interests, we're talking about, might violate an employee's duty of loyalty. So that's a really broad one, but the problem with that is it ends with the employment ending. So during the period of employment, it's great. But if that's all you have, that's not going to protect you when that employee goes to a competitor. If you have a legitimate business interest in the confidentiality of whatever information we're talking about, it can also be protected by contract. And courts in the DMV regularly enforce reasonable restrictions imposed by agreement on employees and contractors and vendors and customers and others working for or doing business with a company. Key question here is whether the restriction is reasonable, and also whether the individual, the entity, will agree to enter into that contract. So sometimes that doesn't work. Most of you here today are probably familiar with and probably administer confidentiality agreements, or NDAs. There are various other names for these agreements, and most of you probably use or are subject to them. And the crux of those is often confidentiality about important proprietary information. When binding an employee, these agreements can survive for reasonable periods after the employment. And that's why it's so important to get these and to make sure that for a reasonable period of time, that may be a couple of years, that may be 5 years, it depends, it may be forever. It's possible to do that after the employment ends. So for these protections, we've done 2 out of the 3 sources. The next one, next slide, the next source of information about or of protection, we got it, is that we want to focus on particularly because it's the source of protection for what truly are the crux of your business secrets, trade secrets. That's the extra protection found in statutes in federal and in state law. In the 3 tri-state area, we have different statutes, and we're focusing on Maryland today, but they all have a lot of important things in common, and Jace is going to be talking about those because it gets more complicated, and I just have a short attention span. So Jace?
Yeah, so we can talk a little bit more specifically about what the statutes do to protect, but just as a general topic and what Lauri has been kind of getting at, I'm sure for those of you who are here today, business operators, managers, and even owners, it would not take very long, I suspect, for each of you to identify some category of information that your business maintains that if it were suddenly emailed to a competitor or posted online could do significant harm to your business. And that is the type of situation that these statutes are designed to protect against and to give you guys remedies to take action if that horrid event were to happen. But as Lauri alluded to, there's kind of 2 different aspects to this thought process. One is that the information itself needs to have some sort of intrinsically valuable properties, it needs to actually have some sort of market value. And that's something that the information either has or it doesn't have. But the second aspect of it is what you guys do in running your business to protect the information and taking active steps to maintain the secrecy in order to get the protection of the law and the protection of the courts. Because if you guys don't implement policies and procedures and actively protecting this information, the court's not going to help you when all of a sudden it gets leaked or it's found out by somebody else. So looking at as Lauri mentioned, there's a lot of different levels of these statutes. There's the federal level, which has all 50 state applicability, and then all of the individual states have also passed laws called the Uniform Act, which is basically the same. I mean, there's little tweaks from here to here, but the overarching concept is very similar from state to state. So when I talk about this, I won't be talking about a specific jurisdiction, but you guys can understand that it's very similar no matter if you're in Virginia, in the district, or in Maryland. So looking to the statutory definition of what constitutes a trade secret, there's really 2 different elements. Well, 2/3, depending on how you divvy them up. The information must derive independent economic value, and it must not be generally known or readily ascertainable to others. And the second element is that you as an operator must have taken reasonable measures to keep it secret. And so, one of the most common situations employers find themselves in when they're getting into hot water with trade secret stuff or confidential information is oftentimes employees who separate from the business and then they go on to compete. And you bring on employees, you get them access to your confidential information because they need it for sales purposes or running the business. And then they develop relationships with customers. And then all of a sudden they learn the business and they want to go out and start a business on their own. And they take this information with them when they walk out the door thinking that they can use it as a jump start on their business. And if you take the protections that we're going to talk about, then you can stop that from happening very effectively. So if we look at the next slide. So these are the DTSA is the federal law and the USTA is the uniform law that states have adopted. And this is kind of the definition of what can constitute trade secret. And you can see it's very broad. I mean, it's all financial, business, scientific, technical, economic patterns, formulas. And I just wanted to put this out here just so that to make the point that this is a very broad definition. Anything can constitute trade secret if it meets those other elements. So this is really kind of a broad protection as long as you follow the other steps. So every business is unique, and this law is trying to protect all of the businesses and all of their operations. So it's a very broad definition. But at the end of the day, if this goes to a court, it's a very fact-intensive analysis. So the court's going to look at what is your type of business? What type of information are you trying to protect, and how do you derive value from that information? And then what steps have you taken to keep that stuff secret? So might just be helpful to talk about a few examples here. So these are all a list of examples that courts have actually found to constitute trade secrets. And most of these are in the DMV area. So you have things like software program or features, code, that type of thing for your programs, which is probably an easy example. One that comes up a ton is customer lists. If you maintain a private list of your customers and what products and services they're using, that can constitute a trade secret. Internal aggregation of market data. So one of the things we're talking about is this idea of private information versus public information. But if you go out in the marketplace and you take publicly available data about market trends or customers or that sort of thing, and then you put it together in a way that's useful for your specific business, and then you use that and you keep it secret, that, taking information that's publicly available and then taking it and making it useful for your specific business can also become a trade secret if you maintain the secrecy. Company operating procedures. The example I listed here, this Brightview group, they ran senior living facilities, and they had a standard operating procedure that they gave to all their employees about how we run our business to get the best outcome for our seniors. And that was taken. And the court found that that methodology of how you deliver your services to your clients is a protectable trade secret, and they had taken steps to protect it from disclosure. A couple of examples that seem to be coming up a lot lately that we've been dealing with are, mailing lists. We've got a couple of cases where an employee separates, and on the way out, they take the emails of all the employees. And since they have the same skill sets and can provide the same services, contacting customers is oftentimes the barrier between a competitor and your business, because they don't have access to that identified market segment of customers that are seeking precisely your services. So if you maintain those types of lists and you keep them secret, they can also become trade secrets that courts will protect against the disclosure of. On the flip side, just kind of good examples of what's not a trade secret. There's a couple instances in which, financial information generally. There was a case where a financial firm tried to get trade secret protection over publicly available financial information, like stuff filed with the SEC. If you can get it from a public source, but you don't do anything extra with it when it comes into your business, it's not going to get the kind of protections we're talking about. Even if, as Lauri talked about, you can still have confidentiality agreements and other types of things that may give you that sort of protection. And in this last example, I just would like to talk about this concept of business know-how. A lot of times you'll hire an employee, you'll teach them how to do things, skills, other types, operations of your business. And sometimes those processes and skills can become trade secrets. And then other times they're just information that the employee is going to take with them because it doesn't rise to the level of unique enough to your business. And to give this an example, there was one case in which a company had developed a process for for recycling plastic. And they had found a unique way to get foreign objects out of the plastic so that they could sell it and make it into new things. And that know-how was determined to be a trade secret. But on the other side, we had a case in which we represented a security company, and they used, publicly available motion sensors and cameras, anything you could buy at like Best Buy. And they put it together in a way to provide security to their customers. But that was, probably not going to be a trade secret because they didn't do anything special with it. And it was publicly available information that they just kind of gathered together to provide services. So it can be kind of nuanced, but the important thing is to think about what about the way I'm using my information is unique to my business, that somebody who just went on Google or went to and bought one of those, business for dummies books couldn't figure out. And then that information is what needs to be protected. And in terms of taking those steps, I'll turn it back over to Lauri to talk about how you can do that.
So you can see there's a lot of interplay between these things. What is a trade secret? Well, part of what makes it a trade secret can be what you do with it and how you store and maintain it and how you limit access to it. So part two of the part two definition is what are the steps that are taken to keep the information secret? And the more steps, the better, frankly. And they have to be reasonably calculated to keep this information from being disclosed to people who would use it to compete against you or for whatever benign or malign purpose. So what's required to get the protection in addition to having the information that's deserving of the protection? You have to take, and the buzz language is reasonable efforts to maintain its secrecy. You have to make those, and they're going to vary with the nature of the information. They're going to vary with the nature of the storage or use that makes sense for the information. They're going to vary with the nature of the workplace and the staff and who has a need to know the information and who uses the information. There are just so many factors, and they're almost as widely varied as there are types of businesses and different distinct businesses. But the court is looking for a constellation of things that you do that make sense, and no glaring thing that you don't do that would have been reasonable to do. So some things to consider on, I think we have on the slide, next slide. Okay. Oh yeah, I can look over here. Okay. So limiting access, again, need to know basis. With frequent reminders and disclaimers, and it's sort of like early and often, as often as you want to tell people that they shouldn't be using this, you can't do it too much. Confidentiality agreements, we're roping back in that second type of way that you can protect this information. Have those agreements, even if you think that the statute protects you, have those agreements in place. It's one of the things that's going to help make the determination that the statute does protect you. They don't have to be perfect, as you probably know. They just need to be reasonably, again, the word reasonable is second nature to litigators and trial lawyers. We use it all the time because it has to be a reasonable effort or something reasonably calculated to put the contracting party on notice of the prohibitions and to protect the information from disclosure or unauthorized use. So handbook policies on confidentiality are great. If you don't have one, you really should. It's kind of one of the core policies that you need to have. Again, this is one of the several forms that can be used to introduce and reinforce the importance of the information and its secrecy to your employees. Making it known to employees and others that have the information in as many ways as possible that this is sensitive and cannot be disclosed. Marking on it if it's capable of being marked, whether it's in the name of the computer file or whether it's on the item or the document or whatever, confidential or top secret or whatever works, to warn everyone who might get a hold of it that this is not to be disclosed, not to be passed on. Password protections, things like two-factor authentications or two-employee access. Think of a safe deposit box where you go to the bank, and for an old-fashioned, old-school example, and you put your key into the safe deposit box and the bank officer puts their key in. This is the modern version of that. Redundancy, anything you can do to make it harder to get to the information. And they, the number of protections and the type of protections you take should reflect the magnitude of importance and the significance of the risk of loss of that information. Physical protections like locked doors, cabinets, physical security, obviously, because you can have as much password protection, et cetera, as you want, and then you can print it out and leave it on a desk. I mean, we've had situations where things were readily available because, oh, well, yeah, there were printouts of it. I mean, so the computer is all kinds of secured, but somebody printed it out and has it on their bulletin board in their office. I mean, no, that's not gonna be good. And really big companies fall down on these efforts. I mean, we have the case law, which is usually generated by folks who can afford to litigate all the way up into the appellate courts. We got T. Rowe Price cases. We got other cases where they failed to take the right measures, or where it was just found that, well, you took great measures, but this stuff is readily available, as Jace was saying, and it can be reverse engineered or not even reverse engineered easily. So that's just not going to work. So you can take a million precautions and you can't change the nature of what you're protecting, but you can take no precautions and you can have a really important trade secret and you can lose the protection. That's kind of it for me. Jace is going to put together elements 1 and 2 for you and talk about how the trade secrets get really get the protection.
Yeah, and just one final thought on the keeping trade secrets secret. And there's no bright line for how many of these things you have to do in order to what constitutes reasonable efforts to maintain secrecy. But just as a general rule of thumb, I would recommend at least 2, if not 3 or more, of these tactics be employed in order to keep your confidentiality secret. I mean, you're definitely going to want more than just one effort. You have to convince a judge or a jury or whoever it's going to be that you took reasonable steps to do something. So it should be a couple of different steps as part of your process. But in kind of putting it all together.
If the question that someone is going to ask is, well, why didn't you? then that thing is the thing you definitely need to do.
And so here's just kind of a summary. This is from something called the Restatement of Torts, which is kind of like an encyclopedia for lawyers, if you will. And it just kind of puts it all together and saying, like, what are the factors that people consider, specifically courts, in determining whether something is a trade secret. And it kind of hits all the highlights. It says, to the extent that the information is known outside of your business, that publicly available aspect, the extent to which it's known to employees or others involved in the business, that is it a need to know basis, or is it, do you tell everybody about it? Is it just the managers? Is it the owners only? What steps did you take to guard the secrecy, the value of that information, how much effort you went into cultivating it, and the ease or difficulty that it could be kind of created by somebody else. So those are all different factors, and you can kind of take a look at this list and think about what kind of information your business has and see how it stacks up against this, both from a value perspective and also from the steps you're taking to maintain its secrecy. And so the last kind of consideration here is okay, you've taken these reasonable steps, you have valuable information, it's been kept secret, and then all of a sudden, oops, somebody steals it. And the court agrees with you that it is a trade secret. So what can we do to protect it now that it's gone, despite your best reasonable efforts? And there's a couple of different things. And as Lauri has talked about, there's 2 different sources. We have the statutory provisions, which provides for specific remedies that it powers courts to do. And then also there's contractual things like confidentiality provisions, which may apply even if you don't get trade secret status. So I'm going to talk about general remedies, which may apply to both or just one or the other. And I'll try to point it out as we go along here. But, when it comes to secret information, a lot of times it's ongoing harm that's the problem. Once the toothpaste is out of the tube, it can be hard to put it back in, or you want to stop that employee who left from using it on an ongoing basis. Particularly with mailing lists is a big one. Stop emailing my customers. We had one case where a former employee was emailing customers about here are the services I can provide you that are the exact same as what you were getting from that other person. So that sort of active solicitation isn't a one-time event. It could be an ongoing harm. So the courts have the power to use what we call injunctions, which is basically an order saying stop doing that. And there's a couple of different points in the process that you can get that relief. So if a lot of times this is an emergency, it's an active ongoing thing that we want to stop now, not in 2 years when the whole litigation process has kind of concluded. So you can go into court on an emergency basis. We're talking days, not weeks, and get something called a temporary restraining order, which can lead to a preliminary injunction, which would be an order from a court saying stop using that information until we have an opportunity to figure things out, basically. And in the context of trade secrets, it can be easier to get that kind of relief if you can show that an employee is walking out the door with your customer lists or with your mailing lists. So courts are very much willing to impose these things. We've had a few cases just recently in which courts have entered injunctions and TROs restraining former employees from competing against their prior employer or from using that information. So it's a very real thing that courts will do. And then getting to kind of like the end of the process, the ultimate relief that you can get from a court is to make that preliminary injunction a permanent one. So they can say, okay, you can never use that information, or maybe if it's a confidentiality agreement that had a 2 or 3 year term, they could say, okay, for the next 2 years, you can't use that information. So courts can give you that type of relief, which is more than just dollars and cents. How much did this hurt me? And in particular to the trade secret context, the court can enjoin or enter injunctions for threatened or actual misappropriation. So even if somebody say they take a mailing list, they're like, well, I took it, but I haven't actually emailed anybody yet, but the threat is there. And you want that security knowing that even though they have this information, that there's a court order saying don't do anything. We're not trading on goodwill, especially if they've already taken your information. So courts can enjoin threatened use of trade secrets as well as actual use of trade secrets.
That's a nice thing to keep in mind, because many causes of action that your counsel may want to bring for you require that you have damages. But in these situations, when it's an imminent threat of harm and everyone can see what the harm would be, you don't have to prove that you've already been damaged. So you can run in advance and stop, whether stop the bleeding or stop the injury from happening.
And oftentimes that type of injunctive relief is the best measure because, if we're talking about losing customers or using trade secret information, sometimes the actual harm that your business suffers is very difficult to measure. I mean, how many customers did you lose because of this information? How many, are they going to come back? You have a customer that's been loyal for 2 years and then they go to a competitor because they use your information. Well, that customer may have been with your business for the next 10. So how do we measure that? But we don't know exactly how long that your customer would have been there. So sometimes courts are like, that's very speculative about how long that customer would have been loyal to your business. So we can't necessarily determine how much money to give you to compensate you for that wrong. So this type of injunctive relief is there to kind of go above and beyond and make sure that speculative nature of damages and that you don't have to get that far. But if you do, the courts can provide relief in terms of money. If somebody uses your information and generates a profit or you lose business because of it, you can get a judgment on the amount of the actual loss to your business. Or on the flip side, if there was unjust enrichment, this concept of actual loss and unjust enrichment are kind of two sides of the same coin. On one side, you have how much did I lose? But on the other side, you have how much did you gain from using my information? So both of those measures a court can look to in fashioning a relief for somebody who's been a victim of a theft of trade secrets. And in this, situation, as I've been talking about how it can be very difficult to precisely measure things, one other solution that a court can do is say, okay, well, you have this information. We're going to charge you a royalty for that use. So that could be some prospective relief on an ongoing basis that a court could order, since they have the information. It's hard to get it back sometimes. So we're just going to charge you for it. So the court does have some flexibility here in determining how to best compensate it, with the idea that we want to make these people whole, the victims whole. And how do we do that? But sometimes, the business owner would have the burden of proof in showing how much damage to their business occurred. And that can be sometimes a tricky thing to do. And last but not least, these two subsets on the right-hand side here is attorney's fees and exemplary damages. So starting with attorney's fees, if you don't already know, if you haven't been through the litigation process, the default setting in America is that everybody pays for their own lawyers. And sometimes that can be expensive. Most times that can be expensive. So under the statutory scheme for trade secrets, there's a fee shifting provision, which allows for somebody who prevails on an action for trade secrets to recover their attorney's fees. The catch is that you have to show that the misappropriation was willful and malicious, which is unfortunately a relatively high standard. You have to show that basically that the employer, the stealer, the thief, really had an intent to injure your business, that they wanted to just hurt you. And that can be a difficult thing to prove, because a lot of times these secrets are taken just for their own monetary benefit. They think, oh, well, I was servicing that customer when I was working with you, and I want to continue to do it when I've left. So sometimes that can be hard to prove. Obviously, if you have employment agreements or other agreements, you can include contractual provisions, and we encourage you to do so, that says, like, if we have to sue to protect our business or to enforce our rights, that you have to pay our attorney's fees in that enforcement action. And courts will routinely enforce those provisions and award employers their reasonable attorney's fees. And in this last category of exemplary damages, under the trade secret statute specifically, this is not for contracts or anything, but the court can award 2 times the amount of damages as basically punishment for stealing trade secrets. I mean, this is a public policy determination by the legislature that we want to, disincentivize this type of wrongful acts, so the courts can punish people who do this. But that's going to be left to the discretion of the court. And you have to, again, show that intent to injure, maliciousness kind of statute. So those are all different types of ways that you can, if this were to happen, worst case scenario, there's a lot of different ways, both immediately and in the long run, that we can protect your business and hopefully make you whole at the end of that process to put you back where you were before.
So I think we're running a little bit behind. No time for questions. No, I'm kidding. If we have any questions, we're happy to answer.